I found an incredibly important article discussing a case out of Alberta involving an autistic woman who is 27 years old who wants MAID. And she has applied through Alberta Health Services and gotten the requisite 2 doctors to sign off on the application. However, her father, who she lives with, has gotten a temporary injunction to stop her access to MAID. And he is saying that this girl is not mentally capable of making this decision. Now, this article I will post in the description below, but I wanted to read this to you and show you guys exactly what I mean and how important this case is going to be for not just Alberta, but for the rest of Canada in regards to MAID. And I wanted to do this video because it's a follow-up to my discussion of MAID and Veterans Affairs the other day, and how I do believe that there are applications for MAID, that this case illustrates just how important it is to hammer out the framework of this system and make sure that there are various checks and balances to keep things like this case from happening. So this says, the father of a 27-year-old woman who has been approved for medical assistance in dying, or MAID, has asked a Calgary judge to dig into the circumstances that led to 2 of 3 doctors approving his daughter's application. So, and it says here that a publication ban is in place protecting the parties and the medical professionals involved. So CBC is going to identify the daughter as MV and the father as WV. So from here on, that's who the reference is. At issue is whether the courts can step in when family members with no legal standing have concerns about the MAID approval process. Now, this is kind of the opposite of what a lot of people are concerned about. They're concerned about family members utilizing the MAID process to get rid of burdensome family members, or like financially or otherwise abusive family members who are caregivers for other invalid family members abusing this process. This father is trying to basically say, whoa, there are no checks and balances in place to stop my daughter from doing this when, like, there's no reason for her to do it. Currently, 2 doctors or nurse practitioners have to approve a patient for MAID. Now, I think, and no shade thrown on nurse practitioners at all, but I think if you're going to sign off on someone ending their life, you should probably hold an MD. That's just my opinion. The medical practitioner must determine through an assessment that the person has a grievous and irremediable medical condition that causes intolerable and enduring or psychological suffering. So it's not physical and psychological suffering. It's physical or psychological suffering. So that's an important distinction, and I think honestly that it should be both. I think it should be physical and psychological, not or. I think the conjunction there is very important. A previous requirement of MAID, a reasonable foreseeable natural death, was repealed in 2021. And for now, people suffering solely with mental illness are excluded from accessing MAID until 2027. So the father here, it's saying, the Court of King's Bench, Justice Colin Feedsby, heard that MV, who lives with her father, was approved in December, and her date to receive MAID was set for February 1st. So that's a fairly quick turnover rate. I do understand that people who are in charge of this process understand that people seeking MAID obviously don't want to be languishing on a wait list. But a month and a half, because let's say that this was done in mid-December, like just before Christmas, right? Let's say she got the approval in like the teens of December. Then that's a month and a half between approval and actual date of access. That's quick. And that father, could you imagine finding out that your daughter who lives with you has applied for MAID? Now, I don't know the whole case, and I'm hoping that we're going to be able to get more on this case, but I'm wondering if this woman has like the mental capacity of a teenager, maybe 14, 15, and could be capable of taking herself to her own appointments, but is not capable of making big life-altering decisions. So I'm wondering if maybe these doctors who aren't her family doctor and can just see before them an adult seeking MAID, I'm wondering if they're just going off of that. And because if you're like this father clearly doesn't feel that she's a burden. The day before she was scheduled to die, WV was successful in seeking a temporary injunction preventing MV from accessing MAID. She has not submitted any medical documentation that could explain why she qualifies for MAID. That's important. That raises huge red flags to me, because if a doctor's going to sign off on MAID without any supporting documentation, then that really does support my theory that she could have a diminished mental capacity and the approving doctors wouldn't know, because she didn't provide that documentation. In a brief filed with the court, WV argues, quote, MV suffers from autism and possibly other undiagnosed maladies that do not satisfy the eligibility criteria for MAID. That's another huge important problem, because if she has undiagnosed ailments that if they were diagnosed and treated, perhaps she wouldn't feel that MAID was even necessary. So this is huge. And again, this is proof that the approving doctors don't have all of the information. MV's lawyer, Austin Palladdo, argued she's, quote, not trying to withhold or hide anything. Justice Feasby summarized his understanding of MV's position, that she feels she has a right to keep her medical records private. She's, quote, she's saying it's none of WV's or the public's business. I've been approved by 2 doctors. I am entitled to this, and court, it's none of your business either. Well, that's not necessarily true. If you've enlisted doctors to sign off on an application to die and you haven't given them all the pertinent medical information, you're not just putting your life at risk, you are putting the careers and personal lives of two other people at risk, because if it comes out that you were wrongfully given access to MAID, there goes their licenses and they're possibly facing jail time. So it is their business at this point. Sarah Miller, the lawyer for the father, called the situation, quote, a novel issue for Alberta. Oh, not just Alberta, though. For Canada. This is enormously precedent setting, and I wouldn't be surprised if this judge felt not up to the case and passed it to either the Alberta Supreme Court or the Canadian Supreme Court. And I would not be surprised if this became just as influential of a precedent setter as Carter versus Canada did in 2015, which started the whole process of the MAID legislation anyways. This is going to be huge. Quote, as it stands, AHS, Alberta Health Services, operates a MAID system with no legislation, no appeal process, and no means of review, wrote Miller in her brief for the court. That is huge. The fact that there's no legislation, appeal process, or review process, that is huge. That is absolutely unpalatable to me. As I said, I believe that MAID has some very important applications, but there absolutely needs to be legislative framework, a review process, an appeals process. All of that needs to be put into place at every provincial level, and I would argue at the federal level. I would argue that while healthcare is a provincial matter, I would argue that this would also need a federal department just as a checks and balance. The fathers submitted a 2021 report with the court, authored by a doctor at a neurological clinic, who concluded MV required no follow-up and was, quote, normal, and sent her back to her family doctor. That's also hugely important, because 2021 was 2 years before her application, so not very long ago medically. So we have a report before the court saying that she is not, suffering from any neurological disabilities. She's able to, perform daily tasks. She has physical skills, motor skills, all that. So, and now she's saying that, and this is another very important paragraph. Miller also pointed out that on her initial MAID application, MV indicated her death had become, quote, reasonably foreseeable. Yet she was approved as a Track 2 MAID patient, which means death is not reasonably foreseeable. So even the approving doctors are saying that her death is not foreseeable. And when somebody who is applying for this says in their own opinion that their death is reasonably foreseeable, and then two doctors say, okay, yeah, you can die, but you're not reasonably foreseen to die, that's a big incongruity. That's a big discontinuity between the two. And what really bothers me is that two doctors have agreed that there is no reasonable foreseeable death in the future, yet she still is able to access MAID, and they have no medical documentations to make these decisions. I don't understand this. Fees to be heard that two doctors were initially approached by MV. One agreed to sign off on the approving her for MAID. The other denied the application. A third, quote, tiebreaker doctor, as described by lawyers for Alberta Health Services, was then offered to the patient, in this case MV. What the fuck does that mean, a tiebreaker doctor? Does Alberta Health Services just have these, Kevorkian-esque doctors on staff to sign off on patients for MAID? Oh, excuse me, sneeze mid-video. Sorry about that. This is insane, and this is why I'm talking about this being a hugely precedent-setting case. Because all of these checks and balances need to be put into place. Not just in Alberta, but everywhere. WV believes that MV is not eligible for MAID in that her, quote, capacity to consent to MAID is impacted by mental illness. He also feels she's been, quote, unduly influenced by a third party, according to one of the documents filed with the court. That's another problem. How is it that we can't stop one or more family members or friends from pressuring somebody into doing this, and then have a voice of reason step in and go, whoa, no, this can't be done. If the MAID approval process is not followed as set out in the criminal code, medical practitioners could be charged criminally. Yes, this is huge. If she is wrongfully granted access, this is not okay. Like, she is putting two people at risk on top of herself. Quote, if the court can look at this in the criminal context, then the courts can look at this in a pre-criminal context, wrote Miller. Absolutely. If we can establish criminal penalties for MAID, we can establish pre-criminal stopgaps for this. Absolutely. Emily Amerkany, another lawyer for WV, argued that MAID is, quote, an incredibly unique system where if a person seeking MAID is wrongfully approved, quote, then that person is never going to cause anyone to look behind that curtain because they got what they want. Exactly. If you are seeking to die and you don't have a reason to do so medically, and you manage to get doctors to sign off on that, that's a problem. We can't have that happen. And yes, there is the question of medical autonomy, but we also have to protect the people who are mentally incapacitated. And this judge is put in the position to basically second guess doctors and become a medical arbiter. This is a huge problem, and we do need to have the federal government did consider and reject having judges in the position of review and arbitration roles, and I disagree with that. I think we absolutely need the stopgaps and the checks and balances involved to keep things like this from happening. We need the mental health and the mental capacity of people protected, and we need to absolutely have these measures in place now. These cases are going to keep happening, and this case I'm going to keep an eye on because we need we need to keep an eye on this. This is going to end up becoming a Canada-wide decision, I think, and it's going to be just as important as Canada v. Carter. So put your thoughts in the comments below, like, share, and subscribe, and I will see you guys in the next video. Have a wonderful day.